Judge Amy Jackson's dismissal of Roger Stone's motion for a retrial, it reads like a judgment that is arguing from a conclusion as opposed to towards a conclusion. Viva Frei, Montreal litigator turned YouTuber, entering week 8 of the Canadian lockdown, working out of my new office, my car. So for those of you who may not know, Judge Amy Jackson was the judge during the Roger Stone trial. Roger Stone was recently found guilty on 7 charges by a jury of 12 members. Roger Stone recently filed a motion for a retrial before Judge Jackson after it was revealed that one of the jury members might have suffered from a little bit of bias. That jury member was also the jury forewoman. I've done a bunch of videos on the subject, so I'm going to link that playlist right here. Give it a watch if you don't know what's going on before watching this one, because if you don't do that, you're not really going to appreciate what's going on in this vlog. But just for the sake of it, the 30,000-foot overview of the situation before we delve into Judge Jackson's dismissal of Roger Stone's motion for a retrial. Roger Stone was one of the figures that got caught up in the Mueller investigation into the Trump administration, and he ultimately faced 7 charges for obstruction of Congress, lying to Congress, and witness tampering. He sat trial and was found guilty on all 7 charges by a jury of his peers. Judge Amy Jackson, who was the presiding judge for the trial, had placed a gag order on Roger Stone and had ordered the confidentiality of the 12 jury members. After Roger Stone was found guilty, the prosecuting attorneys submitted their sentencing guidelines to Judge Amy Jackson, and they were recommending something like 7 to 9 years in prison for Roger Stone, a 67-year-old man, for a first-time conviction. These sentencing recommendations that were initially submitted to Judge Amy Jackson caught the eyes of certain people, and senior Department of Justice officials intervened to override those recommendations that were submitted to Judge Amy Jackson. This move by senior DOJ officials was sort of embarrassing to some, and out of protest, 4 of the prosecutors withdrew from the Roger Stone file. After 4 of the prosecutors withdrew from the Roger Stone file, one of the jury members went to do an interview on CNN, thus disclosing her identity to the public. After this jury member, who was also the jury forewoman, disclosed her identity to the public, being what it is, started doing something of a due diligence on this person's social media footprint. And people quickly found what many might regard as clear bias that would otherwise disqualify this person from sitting on that jury. Once this information became public and people began to question the neutrality of this jury member, who was also the jury forewoman, people also began asking whether or not this jury member lied on her questionnaire during the jury selection process. And what ended up happening, Roger Stone's attorneys filed a motion for a retrial, and I hope I didn't say motion for a mistrial earlier on in this vlog, but they filed a motion for a retrial on the basis of the alleged bias of this particular juror, and on the basis that she was misleading in the questionnaire that she filled out during the jury selection process. That is the overview of the fact pattern in a nutshell. I hope I didn't get anything wrong, and what ended up happening, Judge Amy Jackson dismissed Roger Stone's attorney's motion for a retrial. This is something I've talked about in previous vlogs, but oftentimes you can tell when someone is arguing from a conclusion as opposed to towards a conclusion. What that basically means is that somebody is starting from a foregone conclusion and they are looking for any evidence to support that conclusion so they can get to that conclusion, which was a foregone conclusion, as opposed to judging from a blank slate towards the conclusion wherever the evidence leads. I read Judge Jackson's 81-page judgment, and it reads like someone who is arguing from a conclusion and not towards a conclusion. The only problem is that that doesn't necessarily make it the wrong conclusion. Now to play the full disclosure game. Now, I wouldn't call Judge Jackson biased because that sort of presumes intentions that I can never prove. I would say this, however, categorically, I disagree with certain decisions she made in law in the context of that trial. I did an amazing live stream with attorney Robert Barnes where we went into detail into the Roger Stone trial, and we discussed the things that Judge Amy Jackson did that are difficult to justify in law, including the gag order on Roger Stone that went into effect before the trial and continued to remain in effect even after the conviction. So to the extent that it might affect your appreciation of my opinion, I do think Judge Jackson made some questionable decisions in the context of this file. With that said, when I saw that the judgment was 81 pages long, the first thing that came to my mind was confuse and conquer. Make the judgment prohibitively long so that you know people are actually not going to read it so they can't understand what might be wrong with your reasoning. The flip side to that, because I'm always self-reflective, is that if the judgment is too short, then one can question the reasoning of the judge and say it wasn't thoughtful enough. While the judgment is 81 pages long, it does include a lot of excerpts from questioning of the witnesses, it does include a lot of footnotes, and it does include a rather thorough 9-page summary. With that said, let's discuss what I feel to be the highlights. On November 15, 2019, the jury returned a unanimous verdict in the case of United States versus Roger J. Stone. It found the defendant guilty of 7 crimes, 1 count of obstructing a congressional investigation, 5 separate counts of making a false statement to the government, and tampering with a witness. Approximately 2 months after the verdict was returned, the U.S. Probation Office completed the pre-sentence investigation, and shortly after that, the parties' sentencing submissions were due. On February 10, 2020, the United States, represented by Timothy Shee, the United States Attorney for the District of Columbia, filed a sentencing memorandum. It bore the names of 4 Assistant United States Attorneys and Special Assistant United States Attorneys who prosecuted the case, and it was approved by their supervisors up to and including the newly appointed U.S. Attorney himself. The memorandum, in accordance with existing Department of Justice policy, advocated in favor of a sentence within the advisory U.S. sentencing guidelines range, which was 7 to 9 years. Here, Judge Jackson is saying that the recommendations that were submitted by the prosecuting attorneys were all within the sentencing guidelines. But a lot of people took issue with the fact that even though this recommendation fit within the guidelines, it was exaggerated to begin with because of the enhancements that were included in coming to that recommendation. This was actually something I talked about with Robert Barnes during our live stream, but a lot of people felt that this recommendation in the first place was puffed up to the max. That evening, the President of the United States commented on Twitter, quote, "This is a horrible and very unfair situation. The real crimes were on the other side as nothing happens to them. Cannot allow this miscarriage of justice." The next day, reportedly at the direction of the Attorney General of the United States Attorney filed a supplemental and amended sentencing memorandum, advancing the position that a guideline sentence, quote, "could be considered excessive and unwarranted, and that a sentence of incarceration far less than the guidelines range would be reasonable under the circumstances." In the wake of those extraordinary developments, another juror spoke out. She expressed her respect and support for the prosecution team on Facebook, and she attached a copy of the first juror's opinion piece as well. The juror identified herself as the foreperson, and she released her post along with her name to the public. This prompted numerous people to search the internet for publicly available information about the author. It didn't take long. They came across several Facebook and Twitter posts that mentioned the special counsel's investigation and several that included negative comments about President Trump, and 2 days later the defendant filed this motion. Defendant contends that he is entitled to a new trial because this, quote, "newly discovered evidence reveals that the foreperson answered questions falsely on her written juror questionnaire and when she was questioned in the courtroom, and that by doing so she concealed the fact that she harbored bias against him." He also seeks a new trial based on an allegation that the juror engaged in misconduct during deliberations, tainting the verdict. That is the overall framework and procedural context, but one small detail that I forgot to mention is that Roger Stone had previously filed a motion to recuse Judge Jackson from the file. Roger Stone had made a motion to disqualify Judge Jackson on the basis that she suffered from bias in the context of this file, and I guess you can imagine what happened with that motion. The irony or paradox of motions to recuse is that they are presented to the judge, the recusal of which is being sought. So above and beyond everything else that went down in this file leading to this motion for a new trial, Roger Stone had also filed a motion to recuse Judge Jackson from the file, which she promptly rejected. And it's in the next paragraph that I think we can get a good impression of what I feel to be the mischaracterization of the question in law that is being submitted to the court. It is important to emphasize that the question before the court is not whether the defense would have taken a different approach towards the juror if it had seen the posts earlier. The trial is over, and a verdict, which was based largely on the defendant's own texts and emails and was amply supported by this undisputed evidence, has been returned. At this point, it is incumbent upon the defendant to demonstrate that the juror lied, and that a truthful answer would have supplied grounds for the court to strike her for cause. Also, a defendant seeking a new trial must establish that the information presented in this motion could not have been discovered earlier through the exercise of due diligence. Only if those criteria are met would one then assess whether the lack of the newly discovered evidence affected the conviction. The defendant has not shown that the juror lied, nor has he shown that the supposedly disqualifying evidence could not have been found through the exercise of due diligence at the time the jury was selected. So here's my issue, and someone please correct me if I'm wrong. I'm not convinced that they would have to show that the juror lied. My understanding is that they would only have to show that the juror concealed information which would have otherwise revealed disqualifying bias. That being said, regardless of whether I'm right or wrong, even assuming that they do in fact have to prove that the juror in fact lied, we are going to see that it would have been virtually, literally impossible to prove that that juror lied. And when I say literally impossible, I don't mean Rachel Maddow literally. I mean literally impossible to prove that that juror lied. Semantically, linguistically, it would have been impossible to prove that the juror lied based on the manner in which she answered the question. But let's get there. As far as I'm concerned, the bigger obstacle for Roger Stone in this motion, and it's one that I'm not sure that they overcame, is proving that they could not have otherwise had access to the information which they are now claiming is newly discovered information. After reading the judgment and now knowing the jury selection process in this particular case, I unfortunately tend to think that this is in fact information that they ought to have found at the time. Setting aside the fact that the jury member's identity was being withheld from the public in virtue of a court order from Judge Jackson, and that they didn't have the Alright, sorry about that. My camera actually overheated and shut off, so I'm going to have to finish this vlog in the backseat of the car. Setting aside the fact that the Roger Stone team didn't have the aggregate knowledge and investigative power of all of social media, it appears from the facts as set out in the judgment that they did nonetheless have a fair bit of time to discover this information on their own. So while this information, that being the social media posts, I think most of us can agree illustrates a certain bias, if not an outright disqualifying bias, while it illustrates that, it was nonetheless information that was discoverable at the time. At the very least from the facts set out in the judgment. The assumption underlying the motion that one can infer from the juror's opinions about the president that she could not fairly consider the evidence against the defendant is not supported by any facts or data and is contrary to controlling legal precedent. The motion is a tower of indignation, but at the end of the day there is little of substance holding it up. Therefore, the request for a new trial will be denied based on the facts and the case law set out in detail in the body of this opinion and which are summarized briefly here. The motion is a tower of indignation. This coming from the judge who refused to recuse herself from the file. Given the publicity that surrounded this prosecution, 120 120 citizens of the District of Columbia were summoned to the courthouse almost 2 months before the trial was scheduled to begin. They were asked to complete a 19-page written questionnaire that the prosecutors and defense attorneys had drafted together. It called for basic information about employment, legal training, and prior involvement in court proceedings. It also included a series of questions designed to uncover any knowledge or opinions about the allegations and the participants in the case, and to explore whether the juries could be fair and impartial to both sides. Defendant complains in his motion that we, quote, now know a great deal about the juror, but much of it, beginning with the juror's name, was plain on the face of the written questionnaire that was in his lawyer's hands as of September 12, 2019. If these facts are accurate, it is extremely material to the analysis of the situation. And this is not to throw Roger Stone's attorneys under the bus, but if it is in fact true that they had weeks, if not months, to do a due diligence into the potential jurors, it becomes much more difficult for them to plausibly allege that this was information that they could not have discovered when it took social media all of a few hours to do it. Indeed, at the hearing on the motion for new trial, counsel for the defendant revealed that there was very little that even he would contend was false about the foreperson's answers. Not to be a cynic, but I take Judge Jackson's characterization of Roger Stone's attorney's admission with a grain of salt. But let's go on to see what else she writes. When pressed to identify a specific lie, Stone's attorney pointed only to those answers in which the juror expressed her subjective belief that she could be fair to the defendant, and to one other question, the one concerning public commentary on certain topics. And when I say that it was literally impossible for Stone's attorneys to prove that the jury foreperson lied, when you start talking about subjective answers, it becomes impossible to prove that someone lied in their subjective answer. Have you written or posted anything for public consumption about the defendant, the House Permanent Select Committee on Intelligence Investigation into Russian Interference in the 2016 presidential election, or the investigation conducted by Special Counsel Robert Mueller? For purposes of this question, writing for public consumption includes blog posts, articles, or posts on internet sites that are accessible to the general public. I can't remember if I did, but I may have shared an article on Facebook, honestly not sure. Now, I may not be a recognized expert on linguistics, although I did in fact study Noam Chomsky's linguistics in philosophy. I did also get a degree in law, and I've been practicing since 2007, but I may not be an expert in linguistics. But let's just see how Judge Jackson addresses this. The defendant has not shown that this answer was false. Notably, the juror did not check either yes or no, and she acknowledged the possibility that she may have shared an article in a Facebook post. So what the defense has to prove is that she lied when she said she was not sure.
My last name is not sure. Oh, thank you.
Do tell Judge Jackson, how is one supposed to be able to prove that someone lied when they said not sure? You're supposed to be able to prove that they were in fact sure when they said they were not sure? The evidentiary burden that Judge Jackson just imposed on Roger Stone is an impossible evidentiary burden. Period. It is always easy to play Monday morning quarterback or backseat driver, so it's especially easy for me sitting in the backseat of my car to say that if I had seen an answer like that, red flags would have gone off left, right, and center. The bigger problem to me as far as Roger Stone is concerned is that these are the answers they got in September 2019. It therefore becomes very difficult for them to say in February 2020 that this was information they could not have otherwise known existed. Defendant has gathered a collection of social media messages into a composite exhibit in support of his motion, but only a small number of them bear on the juror's answer to question 23. With respect to the first part of the question, whether the juror had commented publicly about the defendant Stone's motion, points exactly to 2 social media entries from the 8-month period between Stone's arrest and the completion of the questionnaire, or any time before that relate to the defendant in any way. On January 25, 2019, 9 months before she was summoned to the courthouse, the foreperson posted a link to a lengthy news article published by National Public Radio. It summarized all of the criminal cases that had been brought by the Office of Special Counsel against a large number of people, and it included a straightforward summary of the indictment of Roger Stone, which had been unsealed that morning. And on January 30th, 2019, the foreperson retweeted a post written by someone else who found it ironic that it was the arrest of Roger Stone and not 8 African Americans whose cases had also received news coverage that prompted discussion about reviewing use of force guidelines. These facts are not at all inconsistent with the juror's written answer in September 2019 that she, quote, may have shared an article publicly. While the NPR article was transmitted along with a wry comment, neither post expresses any opinion about Stone or the merits of the charges against him. Agree or disagree with Judge Jackson's assessment of the facts, the fact nonetheless remains that the Roger Stone team had enough information to know to look further. Based on that answer alone in the questionnaire, they had enough information at the time to at the very least know that they should be digging deeper, to the point where it becomes difficult after the fact to claim that you could not have otherwise discovered that information. During the individual questioning of potential jurors on November 5th, the court asked the juror what she had read or heard about the defendant. So nothing that I can recall specifically. I do watch sometimes, paying attention, but sometimes in the background, CNN, the most trusted name in fake news. So I recall just hearing about him being part of the campaign and some belief or reporting around interaction with the Russian probe and interaction with him and people in the country. But I don't have a whole lot of details. I don't pay that close attention or watch C-SPAN. November 5th, nearly 3 weeks after Roger Stone's attorneys were in possession of the duly completed questionnaires. So not only did the team have 3 weeks to look into the social media footprint of this potential juror, this is the answer they get on November 5th. She watches CNN?
How much more bias could a potential juror get?
Stone's suggestion that posts expressing opposition to President Trump betray a bias against him is not supported by any evidence or by the case law. There is no evidence in the record that the general public, Democrats in general, or this juror in particular, knew any details about Roger Stone, what he had done before, what role he played in the campaign, or what his views were on any particular issue. The juror simply knew that he had been charged. I may disagree with this take on the facts, and I may think that this take on the facts is optimistic at best, but I am not the judge, and when one is petitioning the court for a retrial, they have to have sufficient evidence to do so. That being said, I think I can hear a collective shrieking on the internet of people who don't necessarily agree with Judge Jackson's assessment. And later on, in order to justify her conclusion, Judge Jackson writes as follows. So the exhibits introduced by the defendant are consistent with and do not discredit the juror's responses on the questionnaire. This case does not present the extreme situation where a prospective juror has a personal relationship to some aspect of the litigation, or to a participant in the case that would make it highly unlikely that she could remain impartial. For these reasons, the evidence falls far short of defendant's sensational rhetoric, and the defense has not shown that the foreperson's answers during jury selection were false. I am merely a Quebec attorney. I don't know the applicable case law, but something in me tells me that the judge's characterization of the evidentiary burden right now is a little bit exaggerated or a little bit excessive. If that is in fact an accurate description of the evidentiary burden, I leave it to the American lawyers to confirm as much, and if it's not, I leave it to the Court of Appeal to overturn it. There is a second reason why Stone's motion fails. To the extent one could consider any of the social media posts to be inconsistent with the juror's questionnaire, they do not warrant a new trial because they do not meet the legal test for something that has been newly discovered. The information in the motion could have easily been found with the exercise of due diligence, by posing a few pointed follow-up questions in person, or by using the same search engines that quickly brought the public social media post to light the day the juror identified herself to the rest of the world. The evidence the defense claims was critical was never concealed. It was a few clicks of a mouse away. And this is where even the most ardent supporters of Roger Stone are going to have to concede that Judge Jackson is making a valid point. And in the body of the judgment, we go into detail as to how the questionnaires were filled out on September 12th. They were received by counsel for the parties on September 13th. On November 5th, you had questioning of the potential jurors. The jury was selected on November 6th, over 3 weeks after the duly completed questionnaires were received by counsel. And with respect to this juror, Roger Stone's team never made a motion to strike for cause. Plus, the defendant did not ask the juror about her use of social media when he had the chance. The four-persons questionnaire put the defense on notice of the particular media outlets from which she received news and information, the commentators she favored, her personal participation in electoral Democratic politics as a Democrat, the fact that she received information from Facebook and Twitter, and, significantly, the fact that she shared on those platforms herself. She candidly set forth the fact that she followed the Mueller investigation somewhat closely, that she had read or heard something about the case, and that she indeed had opinions about the officials on the list of names that might come up during the trial. Now, we do have to look at this from both sides. It's all fine and well that Judge Jackson says that the Roger Stone team had access to all of this information and they could have asked more questions. The court had access to all of this information as well. How on earth did they not strike her? If this was information that the Roger Stone team had, this was also information that the court had, and in which case the court probably should have struck this juror to begin with. How on earth does the court let such a person sit on the jury, let alone become the jury foreperson? This is one heck of a double-edged sword for the court to be swinging around. Roger Stone's team had all of the information they needed to disqualify this juror. Well, so did the court. And another thing that we all have to bear in mind is that while all of social media was up in arms because we just discovered that this jury foreperson had participated in politics and run for office for the Democratic Party, while we learned that because we just discovered who she was, the defense team, Roger Stone's team, knew that from the beginning. So what was news to social media and the general public was in fact not news to the Roger Stone team. During the individual voir dire on November 5, the juror answered questions posed by both the court and the lawyers. And she was warm, open, and frank. I guess you could say we could call her Frank. The court found her to be extremely credible, and the defense attorneys who had the opportunity to assess her demeanor and friendly presence in the courtroom chose to ask her only a handful of additional questions. Based on what they had read and what they observed, they did not move to strike the juror for cause, and they did not use a peremptory challenge to strike her from the jury pool. All of this suggests that they too found her to be believable, or that they had identified some other information in her questionnaire that made her an attractive juror for the defense, and they made a strategic decision to forego asking her more questions about Facebook or her opinions about Donald Trump. And for those of you who may not know, a peremptory strike is the right of the parties to strike a certain number of jurors for no cause whatsoever. As for the second basis for the motion for a new trial, juror misconduct, defendant contends that the juror did not comply with the court's instructions because her social media posts reveal that during the period between the completion of the questionnaire and the verdict, she was aware of some developments in the news concerning the president or politics. But there was no prohibition against reading or discussing news in general or even news about the president. The jurors were told to turn away from any publicity concerning the case. For that reason, the defense conceded at the hearing that the juror did not transmit any posts during the trial in violation of the court's instructions not to communicate about the case. Question those instructions from the judge as much as you want, and I can't really think of another way to end that sentence. At the hearing for the motion for a new trial, the court heard the testimony of 2 of the jury members. The court basically asked those jury members if the deliberation process was conducted properly, and the jury members said yes. The court: did you have any concerns at the time you rendered your verdict about whether you and the jury had engaged in a full and fair consideration of the evidence? We had a problem with, well, I don't know how you say this. Most of us agreed on our answer. We already said that, he was guilty, but it was the foreman. It was the foreman that insisted that we examine examine charge 3 a little more. Okay, there was a count that you sent out some notes about. Is that the one that the foreperson asked you to be more careful? Juror B: yes, that's the one. We needed to examine that a little more and read the transcript, find out more evidence. The court: so it was the foreperson who insisted that the level of attention be paid to that account, even though some of you were already to decide. Juror B: yes. While it was the defendant who requested a hearing on this issue, the defense declined to ask Juror B or Juror A any questions at all. The jurors' accounts stand uncontested, and they were consistent with the record in the case, which includes 2 notes signed by the foreperson asking careful questions about the intricacies of the counts. So the portion of the motion for new trial based on misconduct will be denied because there is no evidence of any misconduct. During jury selection, the defense made a decision that it would not ask to strike the juror for cause, and that it would choose to seat her on the jury by foregoing the use of one of its peremptory strikes. The other jurors' testimony at the hearing supports a conclusion that any judgment made by the defense at the time, based on all of the information in the jury questionnaire, the jury consultant's input, the combined experience and instincts of all the members of the trial team, and the foreperson's answers and sincere demeanor at voir dire, was prescient and sound. The foreperson held the government to its burden of proof, and the foreperson ensured that the jury took its time and considered each count individually in light of the evidence in the case, the jury instructions, and the presumption of innocence. For all of these reasons, then, as explained further below, the motion for a new trial will be denied. I'm not going to go into all of the detail in the 70+ pages of the judgment because I actually don't think it's going to add anything substantive in terms of understanding the issues. It's a tremendous amount of detail that I suspect is really only in there to support any potential appeal of this decision, but it doesn't really add anything more to the thorough summary of the 8-page summary of the intro. I'm nonetheless including a link to the judgment in the pinned comment below if you are so inclined to go ahead and read it. And with that said, if you like my videos and you like my content, please be sure to like, share, subscribe, hit the notification bell so you know when I put up a new video. Share my channel with someone you think might appreciate it. If you want to support the channel, those links are also in the pinned comment. And with that said, take care of yourselves, stay safe, stay sane, get exercise, vitamin C, vitamin D, and what else do you need? Sunlight, lots of sunlight, and now you know your vlog. Peace out.